So, we'll discuss question number 47. What do you understand why the phrase keeping alive a mortgage as provided? The very answer we found under section 101 of the Transfer of Property Act, which discusses about keeping alive a mortgage, and in that connection we'll discuss the very ruling of an English leading case, Tolman versus Tier, and in that also case, the very principle of keeping alive a mortgage is discussed. So, formally, the rule was that when a mortgagee acquired the right of redemption in his security, the mortgage was extinguished unless he expressly reserved the continuance of such mortgage. But in the leading case, Tolmini in versus Tia, it was held that the purchaser of an equity of redemption with notice of subsequent encumbrances stood in the same situation as if he himself had been the mortgagor and could not set off against such subsequent encumbrances either a prior mortgage of his own or mortgage which he might have paid off. A purchaser of the equity of redemption could easily, however, take steps to defeat the very effect of another important ruling of a leading case, and that is Tolman's case, by simply stating that the original debt paid off succeeded for his benefit. The rule, as held in Tolman's case, was embodied in the section 101, but the decision in that case had been more than once questioned in English courts. In particular, in Thorne's case in 1895, the Court of Appeal, where Lord Herschel observed with regard to Tolman's case as a case which certainly has not met with universal acceptance, and it has often been commented upon and criticized adversely. So, in several cases, the Privy Council laid it down that in each case it will depend on the intention of the parties whether a particular encumbrance was extinguished or subsided. So, in the very leading case, Gokul Das versus Rambaks, a Privy Council case, as it was pronounced by Sir Richard Koch, that after reviewing the Indian decision on the point which followed the rule in Tolman's case, he objected to the doubt as to that case or the Tolman's versus Tier or the propriety of introducing the doctrine of it into India as a rule of justice, equity, and good conscience do not seem to have been considered by the High Court of Calcutta or Bombay. So the doctrine of Tolman versus Tier is not applicable to Indian transactions except as the law of justice, equity, and good conscience, and if it rested on any broad intelligible principle of justice, it might properly be so applied, but it rests on no such principle. If it did, it could not be excluded or defeated by declarations of intention or formal devices of conveniences, whereas it is defeated every day when an estate is burdened by a succession of mortgages and the owner of an ulterior interest pays off an earlier mortgage, it is a matter of course to have it assigned to a trustee for his benefit as against intermediate mortgages to whom he is not personally liable. So in India, the act of conveyancing has been and is of a very simple character. Their lordship cannot find that a formal transfer of a mortgage is ever made, or an intention to keep it alive ever formally expressed. To apply to such a practice the doctrine of Tolman's versus steer seems to them likely not to promote justice and equity, but to lead to confusion, to multiplication of documents, to useless technicalities, to expense, and to litigation. So, in an important leading case, that is Mali Reddy, I.R. Reddy versus Gopal Krishnappa, the Madras case where the Privy Council made the observation that it is now settled law that there in India there are several mortgages on a property. The owner of the property is subject to the mortgage may, if he pays off an earlier charge, treat himself as buying it and stand in the same position as his vendor, or to put it in another way, he may keep the encumbrance alive for his benefit and thus come in before a later mortgagee. So section 101 gives effect to the above weighty observations, and under it the intention to keep alive the mortgage is presumed. So the very conclusion regarding the observation made by Privy Council in the case of Gokul Das versus Rambaks would like to discuss and conclude the very relevant answer to this question. What do you understand why the phrase keeping alive a mortgage? So, in this problem, there is a presumption that wise mortgage is not extinguished. The observation made in the Privy Council case of Gokul Das versus Rambaks may be aptly quoted here. The observation made by the Privy Council in this case is that the obvious question to ask in the interest of justice, equity, and good conscience is what was the intention of the party paying off the charge. He had a right to extinguish it and a right to keep it alive. What was his intention? If there is no express evidence of it, what intention should be ascribed to him? The ordinary rule is that a man having a right to act in either of two ways shall be assumed to have acted according to his own interest. Jet can sell the land, but he must pay off wise mortgage, as it was decided by their lordship, the Privy Council. In this important leading case, Gokul Das versus Ram Bhaks, while determining the very scope and application of this very principle or the phrase keeping alive a mortgage so as provided under section 101 of the Transfer of Property Act, and as regarding the very doctrine that was pronounced in Tolman's versus Steer case, so also in Throne case of 1895 in the Court of Appeal, the observation made by Lord Herschel, and so also in Gokul Das versus Rambach's case, which was decided by Privy Council, the very observation was made by Sir Richard Cook. And another important leading case also decided by the Privy Council, Mali Reddy Iyer Reddy versus Gopal Krishna, and it was a Madras case. So the very doctrine or principle that of keeping alive a mortgage and how it relating to the interest of justice, equity, and good conscience, and what is the intention of the mortgage. So, this is all we found as the relevant answer to this question. What do you understand why the phrase keeping alive a mortgage? So, in our next upcoming video, we'll discuss question number 48, which asks explain the very doctrine of taking of mortgages.